Our presentation today is, hey, do you have a minute? And this presentation was designed specifically for small businesses. We are going to talk about both the Connecticut Paid Leave Program and the Connecticut Family and Medical Leave Act. And the reason we titled it as such is that we know oftentimes it's probably the end of the day, it's 5 o'clock, you get a knock at your door, and an employee comes in and says, hey, do you have a minute? And inevitably the conversation is likely around them needing to take some time off from work. So we thought that was a apt title. Just a quick rundown of what we are going to discuss today. We will be talking about the paid leave program, as I mentioned, but also about Connecticut FMLA, because there are some pretty significant changes happening with Connecticut FMLA that go into effect on January 1st, 2022. That will make FMLA applicable to many more businesses than it has been in the past. So we're going to talk about that and how FMLA and Connecticut paid leave work together, and also how they're different. We'll also talk about the implementation of both of those different laws, and we'll leave you with some additional resources where you can get more information or direct your employees for more information. And of course, we will, as I mentioned, have time for Q&A. So first, let me give you a brief overview of the Connecticut Paid Leave Authority. We are the quasi-public agency that oversees the implementation of the paid leave program. So we have 5 main areas of focus. The first is outreach and engagement. So making sure that everyone who needs to be aware of the program understands what it means for them and what their responsibilities are. We develop the policies and procedures that are needed to run the program. We establish the trust fund contribution rate and receive contributions. It's important to note here that the contribution rate is set by the statute, so we can lower it, but we cannot raise it. The maximum has already been set. We approve and audit private plans. That's for employers who would prefer to purchase their own private insurance plan for this purpose, as opposed to participating in the state plan. And what's probably on the top of everyone's minds right now is that we administer claims for the paid leave benefits, and that will begin on January 1st, the benefit payments. So some key dates looking back at the past year. Last November, we began registering employers for the program. It is a requirement for most businesses in the state to participate, and I'll go into who's covered and who is not in just a moment. On January 1st of this year, employers were to begin deducting contributions from their employees, so 1/2 of 1%. In February, we started accepting private plan applications. Quarterly, we receive the contributions that are submitted to the Connecticut Paid Leave Authority from employers. There is a 30-day grace period at the end of the quarter. So for example, first quarter payments were due by April 30th, second quarter payments due by July 31st, and so on. Starting just a few weeks ago on December 1st, we opened our application portal and application toll-free number and began accepting applications for folks who are anticipating taking leave and using this benefit come January. And starting on January 1st, people will actually be able to receive the benefit for approved time off. So let's talk about who's covered under the Connecticut Paid Leave Program. So by law, employers who have 1 or more people working in Connecticut are considered covered employers, and that does include nonprofits and private sector employers with a unionized workforce. Now, sole proprietors or self-employed individuals are not required to participate, but they do have the option to opt in if they would like to. If they do opt in, they have to remain in the program for a minimum of 3 years. There are some exclusions as to who is not covered by the Connecticut Paid Leave Program. That includes employees of the federal government, unionized employees of the state of Connecticut, except as to covered public employees, which I'll speak about momentarily. Municipalities and local or regional boards of education are also exempt unless they have covered public employees. And non-public elementary or secondary schools, which we often call independent schools, are also not covered. Then a few other exceptions, as these folks have other laws that provide this benefit for them. That includes railroad workers, people who are employed by the government of another state. So for example, a Connecticut resident who works for the government of Massachusetts or Rhode Island would not be covered. Employees of sovereign nations, which includes our 2 casinos here in the state. Employees who work in interstate commerce, so they might work in Connecticut, but they live in another state, and so they pay their income taxes to that other state. They would also not be covered. And lastly, spouses of active duty military who do not pay taxes in the state where their spouse is deployed, but instead pay taxes in their home state. Now, I mentioned a couple of exceptions where if the employer has covered public employees, they would be able to participate in the program. Now, that includes non-unionized employees of the state of Connecticut. It also includes unionized employees of the state who collectively bargain to be included. And the same is true of municipalities and local or regional boards of ed. If the bargaining unit does bargain to be included in the program, then both the unionized and non-unionized employees would be covered by the program. And you can see at the bottom of the slide the definition of municipality. It's pretty broad, so it does include the things we would normally think of, like towns, cities, boroughs, but it also includes things like housing authorities, tourism districts, flood commissions, etc. Now, you heard me mention sole proprietors, self-employed individuals, independent contractors. Again, they are not required by statute to participate, but they can participate if they would like to. They can choose to opt in. If you pay self-employment taxes as defined by the IRS, then you are not considered an employee, and that's how you would know that you do not need to participate in the program. If you do enroll, you would contribute half of 1% of your self-employment earnings, so at the same rate as all other employees who are contributing. And again, you would have to stay enrolled in the program for at least 3 years. Now, if you're a sole proprietor, but you do have employees on your payroll, even if you choose not to opt in for yourself, you do have to deduct that half of 1% and remit those contributions for your employees. And lastly, if you receive a W-2, then you are considered to be an employee under the law and you must participate in the program. And that's true even if you're the owner or an officer of the company. Now, let's talk a little bit about the contributions and how that works. So the contributions are deducted from employee paychecks at the rate of 0.5%. The contributions are post-tax and they're based on the employee's wages as calculated for FICA. The employer remits those contributions to us quarterly. And when we receive the contributions, we do validate the amount against data we have from other state agencies to ensure that it's accurate. We deposit those contributions into the Paid Leave Trust Fund, which is managed by the Office of the Treasurer. And then the Paid Leave Trust Fund is the source from which the benefits will be paid starting in January. Now, contributions are capped at the Social Security contribution limit, which this year is $142,800. So that works out to be $714 per year. So even an employee earning above that $142,800 would not contribute more than the $714 per year. Now let's get into FMLA and how it interacts with Connecticut paid leave. So FMLA, you may or may not be familiar with. It stands for the Family and Medical Leave Act, and there's both a federal law and a state of Connecticut law. FMLA, both on the federal and state side, has been around since the 1990s. And what FMLA does is provides job protection for someone who has to take time away from their job for certain family or health reasons. It does not provide income replacement. So it gives the employee the ability to get their same job back when they return from their leave, but there's no source of income replacement necessarily that's provided for by the law. Some employers do provide some source of income replacement to employees when they're out on leave. So for example, some provide a certain amount of paid time off. Some provide paid maternity or paternity leave, for example, but that's not a requirement of the law. And as I had mentioned at the beginning, Connecticut FMLA will be changing pretty significantly in just a few weeks when we head into 2022. Here are the big changes. So right now, Connecticut FMLA stipulates that to be eligible for job protection, a person must have worked for at least 1,000 hours in the past 12 months. That hours worked requirement will be going away. So there will no longer be a minimum number of hours worked for job protection eligibility. Additionally, beyond just the number of hours, the person must have worked for their employer for at least 12 months. That will change to 3 months. So job protection will attach for an employee after 3 months of employment with no minimum number of hours worked. The most substantial change, in my opinion, is that now Connecticut FMLA in 2022 will apply to businesses with 1 or more employees. Currently, that threshold is 75 or more. So we know that there's a whole group of employers who have never had to consider FMLA before. And that's part of the reason that we're providing this training in conjunction with the Connecticut paid leave information. There are also some expanded reasons for leave, which I'll get into. And there's an expanded and more inclusive definition of family. So essentially what happened was the law that created the Connecticut Paid Leave Authority and the Paid Leave Program also expanded the Connecticut FMLA law and implemented these changes. Again, just a side-by-side comparison of what I just walked through. So currently you see on the left what the FMLA requirements are, and then on the right, what they will become 2022. In 2022, if you are an employer with 1 or more employees, you will need to consider job protection for an employee taking leave, as long as they have been employed with you for at least 3 months, and they will not have an hours worked requirement. The length of time is also changing. So currently, Connecticut FMLA provides for 16 weeks of leave in a 24-month period, or up to 26 weeks of leave if the leave reason is for military caregiving. The law will change to provide up to 12 weeks of leave in a 12-month period for all leave reasons, except for the military caregiver leave, which will continue to reflect what is currently available. And additionally, there may be 2 more weeks of leave available for incapacitation during pregnancy. Lastly, excuse me. Lastly, currently an employer can require their employees to use all of their accrued paid time off in order to have income replacement during their leave. That will also change. So while the employer can require employees to use some of their accrued paid time off when they're on leave, starting in 2022, they have to permit them to retain up to 2 weeks of their accrued PTO for future use if they would like to do that. Now let's talk a little bit about what Connecticut paid leave is. So Connecticut paid leave is sort of the flip side of FMLA, where it provides income replacement, but it does not provide job protection. We often use the acronym CTPL, and we use it to refer to the statute, so the law itself, the program, and also ourselves here at the Connecticut Paid Leave Authority. So, and you may also hear the acronym PFML, or Paid Family and Medical Leave, to refer to this. So someone could be eligible for FMLA, so eligible for job protection, but not eligible for Connecticut paid leave. They're not mutually exclusive. There are 6 different reasons that someone can apply for either job protection under FMLA and or benefits under Connecticut paid leave. And that's one of the reasons why it's so tough to talk about one without the other, because the reasons that someone might be able to receive benefits are also the same in most cases as the reasons they could apply for job protection. The first reason is called medical leave, and medical leave is taken by a worker to receive treatment for or recover from their own serious health condition. Now, serving as an organ or bone marrow donor does fall under that serious health condition, and pregnancy does as well. Bonding leave is, bonding is the emotional and physical attachment between a parent and a child. So bonding leave can be taken by a worker to bond with a new child who has entered their home through birth, adoption, or foster care. Both mothers and fathers can take bonding leave, and it can be taken anytime during the 12 months immediately after the birth or the child's placement in the home. And as I mentioned, it does also apply to foster and adoptive children. And in those cases, the bonding leave can also be used for pre-placement activities. The third kind of leave is called caregiver leave, and that is leave that a worker would take to provide physical or psychological care or comfort to a family member who's experiencing a serious health condition. Now, Connecticut is one of only 2 states, I believe New Jersey is the other, that has a provision for family violence leave. And under Connecticut paid leave, someone can apply for and receive up to 12 days in a calendar year for family violence leave. A victim of family violence can take this leave for reasons like obtaining services from a victim services organization, relocating, participating in civil or criminal proceedings, or seeking medical or psychological care. And then our last 2 types of leave apply to military. One is called qualifying exigency leave, and that's leave that a worker can take if they are notified that their spouse, child, or parent has been called to federal active duty. They may need to address certain issues before that person is deployed. So they might need to see their lawyer or take care of some financial arrangements, make alternate arrangements for childcare. So those would all be reasons that possibly could qualify for qualifying exigency leave. And lastly, military caregiver leave. So just like caregiver leave, but it is taken to care for a military family member who is injured during active duty in the armed forces. Now, I do want to talk a little bit about caregiver leave because, as I mentioned, there's an expanded definition of family that is going into effect that will impact who an employee can take time off for to provide care. So the relationships that are listed in the statute as family relationships include a parent, a spouse, a child of any age, a sibling, a grandparent, a grandchild, or an individual related to the employee by blood or affinity. So what does that mean? Related by affinity basically means if someone can indicate that the relationship they share with a person, even if they don't have a blood or legal relationship, is like one of the family relationships that I just listed, that they can take time to care for that person. So here are a couple of examples. One might be, say you have an aunt or an uncle who relies on their niece or nephew for unpaid care, and they maintain a relationship like that of a parent and a child. That could be considered relationship by affinity. Another example might be an unmarried couple who live together, own a home together, maybe they have kids together, but they're not legally married. So with this definition of relationship by affinity, they would be able to take time off to care for each other if needed. And really the whole point of this was to be more inclusive of the definition of family and the different kinds of family that exist. Let's take a look at eligibility requirements. So we've already talked about Connecticut FMLA, but for this purpose, I put it into the chart so that you can see it side by side with federal FMLA and with Connecticut paid leave. So keep in mind, and I will say, I'm sorry if I sound like a broken record going through this, but it is a really important distinction that FMLA is job protection. Connecticut paid leave is income replacement. So over on the left side, we have federal FMLA. Federal FMLA is not changing, and it only applies to businesses with 50 or more employees. So if you don't have 50 or more employees, this is not anything that would impact you. If you do, you probably are already aware of it. For federal FMLA to be eligible for job protection, an employee must have been employed for at least 12 months and must have worked at least 1,250 hours in the 12 months immediately before their leave. Under the Connecticut laws, as they will stand starting in January, the employee must have been employed for at least 3 months, and there's no longer going to be any hours worked requirement. Now, those are the job protected portions provided by FMLA. Over in the column on the right, you see the eligibility requirements for Connecticut paid leave benefits. And these are slightly different. So there's a minimum earnings requirement, which is that the employee must have earned at least $2,325 in the highest earning quarter of what's called the base period. So the 4 of the past 5 most recently completed quarters. Now, this minimum earning requirement can come from more than one employer. So if you have a part-time employee who works 2 or 3 jobs, if their earnings total $2,325 or more in that base period from the multiple employers, then they would meet this criteria. And then additionally, they must be either currently employed and working in Connecticut with a covered employer, or they were employed and working in Connecticut during the past 12 weeks. So for example, perhaps someone left their job 6 weeks ago. They could still qualify for Connecticut paid leave if they met that earning requirement. And then lastly, a note again about sole proprietors and self-employed. They have to be residents of Connecticut who have opted into the plan to participate. There is not a residency requirement for other employees, but for sole proprietors or self-employed, there is that residency requirement. Now, how much either job protected leave or what are the length of the benefits that can be received under these different programs? Federal FMLA provides up to 12 weeks of job protection in a 12-month period for all leave reasons, except for military caregiver leave, in which an employee can be eligible for up to 26 weeks in a 12-month period. For Connecticut FMLA come January, there will also be up to 12 weeks available in a 12-month period for all leave reasons, and the 26 weeks will be available for military caregiver leave. So in those ways, Connecticut FMLA will mirror federal FMLA. Additionally, in Connecticut, job protection under Connecticut FMLA can be provided to folks under the Family Violence Leave Act, and that will provide for up to 12 days in a calendar year of job protection. Also, an employee can be eligible for an additional 2 weeks of leave for incapacity that occurs during their pregnancy. Now, as far as the benefits go, Connecticut paid leave benefits, up to 12 weeks are available in a 12-month period for all reasons, including military caregiver leave. So if someone is taking military caregiver leave, they could receive up to 26 weeks of job protected leave, but only 12 of those weeks would be eligible for payment under Connecticut paid leave. As with job protection, there are up to 12 days of income replacement available for family violence leave, and the additional 2 weeks of income replacement for incapacitation during pregnancy are also available under Connecticut paid leave. So I've given you a lot of information. Let's talk about how this all comes together and how you implement the Connecticut Paid Leave Act. So we have 4 kind of buckets of responsibilities for Connecticut paid leave claims. And one thing that I want to start by saying is that the majority of the burden of the administration of this falls on the employee. There's actually pretty minimal steps that the employer needs to take, but we do want you to be aware of what the process looks like. So the worker, if they're going to be taking time off from you, obviously we advise that they let you know that. We don't want it to come as a surprise. And we ask that they submit their application in a timely fashion, which means 30 days in advance for foreseen leave reasons. So a planned surgery, they know approximately when their baby will be due, etc. And as soon as practicable for unforeseen circumstances. Then in order to submit a claim, we have 2 different ways of doing that, both through our online portal and through calling our claims administrator. So we would ask them to create an online account with us and do their application online if they're comfortable doing that, provide the supporting documentation that we request from them, update their account with absence info and any other sources of income that they're receiving. As the employer, once the employee submits their application, they will receive a packet of information indicating what we need from them in order to assess their claim. One piece of information is called the employment verification form, and that's where you as the employer come in. They will give you that form, and it's a short form. I have an example of it in here to show you, where you'll fill out their typical work schedule and some other information, and you'll return that directly to our third-party administrator, which is AFLAC. On that form, we'll also ask you to validate any other sources of income. Beyond that, we would advise that you make sure that your workers know about your PTO policies, your short-term disability policies, and of course, refrain from any discrimination or retaliation against the worker. At the Paid Leave Authority, in conjunction with AFLAC, our third-party claims provider, we will review all of the documentation. We'll determine if the worker is eligible based on the eligibility criteria. We will approve and deny the claim as appropriate, calculate what the benefit should be and issue the payment. We'll assess requests for reconsideration in the event that the claim is denied, and investigate potential fraud or impose penalties as appropriate. Now, if someone would like to appeal the denial of their claim, that will be handled by the Connecticut Department of Labor. So again, just another way for you to visualize the process. So the worker submits their claim to Connecticut Paid Leave. They submit their application checklist and supporting documentation. AFLAC determines their eligibility. We verify their earnings via DOL data and other sources of data from other state agencies. AFLAC will validate if the worker is employed by a covered employer or if they're a sole proprietor, if they have registered for the program. And then after determining the eligibility, AFLAC will determine if the claim is approved. Of course, they'll notify the worker if any documentation is missing. And if the claim is denied, the first recourse for the worker is to request a reconsideration where the whole claim will be evaluated again. AFLAC calculates the benefit payments and issues the benefit payments. There are two ways for workers to receive those payments, either direct deposit into their bank account or via what's called a stored value card, which is essentially a preloaded Visa debit card. Benefits are issued on Tuesdays and they're paid 2 weeks in arrears. So for example, if someone was approved for a week of leave from January 2nd to January 8th, they would actually receive their first benefit payment on January 18th. And then the worker is to keep AFLAC appraised of any changes, including if they can come back to work earlier, if they need an extension, if they are receiving any other income that they weren't previously, etc. And they are especially, it's especially necessary for them to keep AFLAC updated if they're using intermittent leave, because that, of course, can be unpredictable as far as when someone needs leave for intermittent leave reasons. Here's a copy of the employment verification form. You can find this on our website, but again, your employee will provide this to you when they apply for leave. You can see at the top, they fill in just a little bit of information, and then you fill in the bottom portion. I've just highlighted some areas that we really want to make sure you fill out completely and accurately, because this is how we will communicate with you when a claim is approved or denied. We will contact the contact person with the communication preference that you indicate, either email or mail. When you receive that email or letter, it will tell you the name of the employee, the type of leave they're taking, the start and end dates that were approved, and the weekly benefit that they'll be receiving. Now I'm going to go through the benefit calculation, but I'll preface it by saying it is a rather complicated formula. It's not something that you need to calculate yourself. And if you do have a worker who's interested to know how much they might be eligible for, we do have a benefits estimator on our website, and I'll show you how to get to that. So a few things to keep in mind. One is that the maximum weekly benefit is capped at 60 times the state minimum wage. So currently our minimum wage here in Connecticut is $13, which means the weekly benefit maximum is $780. And a worker can never receive more than 100% of their normal wages if there's a combination of Connecticut paid leave and employer provided PTO or short-term disability, for example. So we have two scenarios. In the scenario on the left, our worker earns minimum wage. This is a pretty straightforward calculation. If the worker earns minimum wage, they would receive 95% of their base weekly earnings. So base weekly earnings in this instance, our worker works 40 hours per week at $13 per hour. Their base weekly earnings are $520 per week, and they receive 95% of that, which is $494. In our second scenario, worker B earns above minimum wage. So the formula is sort of two parts. We take 95% of the base weekly earnings based on minimum wage, so what we just calculated over on the left, and then we add 60% of the difference between the worker's actual wages and the 520 that we calculated previously. So in this instance, our worker would receive $506 in weekly benefits. Now, if someone asks you how much they can potentially expect to receive, you can direct them to our website. On our claims page, we have a benefits estimator where they can select the pay period frequency and their gross earnings. And when they click estimate, they will receive an estimation of what they can expect to receive. We are really clear on the website and want to make sure everyone understands that it is an estimation. That's why we call it an estimator, not a calculator, because there are a lot of different factors that could impact this, particularly if the worker is receiving other income replacement, either through the employer or short-term disability plan. Now, that's a segue into how does Connecticut paid leave interact with any other payments that the employee might be receiving from their employer. So we have 4 different scenarios to illustrate this. Scenario 1, the worker has no PTO to use for FMLA. So they're going out on leave because they need to have surgery. They're going to be out for a few weeks and they have no accrued PTO. In that case, the worker would be eligible for the full amount of the Connecticut paid leave benefit for the full period of their leave. And that's pretty straightforward. In the second scenario, our worker has enough PTO from their employer to cover their entire leave. So in that case, the worker would not be eligible for any Connecticut paid leave benefits because they're already receiving full income replacement from their employer. Scenarios 3 and 4 are where it becomes a little bit more complicated. In scenario 3, our worker has available PTO at their regular pay that will cover part of their time out on leave. So in this instance, the Connecticut paid leave benefit would start after the employer provided PTO is exhausted. And then in our last scenario, the worker has PTO that would cover the full time that they're out, but it's less than their regular pay. So in that instance, the worker would be eligible for benefits at the beginning of their leave, but the employer would coordinate the benefits so that they did not receive more than 100% of their regular pay. And again, we want to make sure that you remember that pursuant to the changes in the Connecticut FMLA law, the employers do need to permit their employees to keep up to 2 weeks of their PTO for future use. That does not mean that it has to roll over from year to year. It just means that, for example, if your employee is going out on leave in February, say their doctor indicates they'll need to be out for 4 weeks for recovery, they have 4 weeks of PTO available. Under the new law, you as the employer could require them to use 2 of their 4 weeks. They as the employee can choose to use the additional 2 weeks if they would like to, but if they would like to keep those 2 weeks to use at a later point in the year, you have to allow them to do that. So what are the important things you need to tell your workers now in advance of them taking any leave? The first is, will you require or permit them to use any employer provided PTO while they're out on leave? The second would be, are there any rules about the use of that time? So for example, if a worker is taking time off to care for a family member, can they use their own sick time for caregiver leave, or do they need to use vacation time? And then the third is in regards to short-term disability. If you offer a short-term disability policy, what does the policy say? We often receive the question about who would pay first. Would it be short-term disability? Would it be Connecticut paid leave? And that really is dependent on the way the policy is written. In many cases, the policies state that the short-term disability plan is the payer of last resort, but it does really depend on the plan. So that's how the Connecticut paid leave program works. Now, what about Connecticut FMLA? Because if you're an employer with between 1 and 74 employees, you probably have not had to provide job protection under Connecticut FMLA before. So what happens if someone tells you that they need to do that? Again, we have 4 buckets of responsibility. The worker will notify you about their need to take time off. They would submit their application for Connecticut FMLA directly to you. So while with Connecticut paid leave, the paid leave authority manages the process, with Connecticut FMLA, it really is the coordination between the employer and the employee. And in conjunction, you determine if they are eligible for job protection based on the Connecticut law. So they would submit their application directly to you, provide you with any supporting documentation, and of course, comply with your attendance and call-in policies. It's important that you as the employer have an established leave policy, including rules about your PTO usage. and that's really clear and is administered in the same way for all employees. You will process the leave requests, monitor the leave usage to make sure that they don't go over the amount of approved FMLA time according to their medical certifications, manage their return to work, and of course, again, refrain from discriminating. The Connecticut Paid Leave Authority has no official responsibilities related to Connecticut FMLA. Connecticut FMLA is under the purview of the Department of Labor. We provide this training because, as you can see, it would be pretty impossible to talk about paid leave without talking about FMLA. But we don't have any official responsibilities. So the Department of Labor provides guidance to workers and employers about FMLA and investigates complaints related to the denial of FMLA. I know that the DOL is currently in the process of updating all their forms. They have a new landing page where they will be putting all of that information as well. So the process, if someone notifies you that they need to take time off from work. So if they come to you, they say, hey, I need to go out because I'm having surgery. They don't have to use the term FMLA, but if it seems like it is a reason that could potentially be covered under FMLA and provide job protection, then you need to go through this process. The employer will determine if the worker is eligible for Connecticut FMLA and will notify the worker if they need any other documents. So you have 5 days from the day that the worker comes to you and says they need to take some time off to determine if they are eligible for job protection. That's not the leave approval, that's just that you letting them know that the reason they're going out either does or does not qualify for job protection. The worker would then provide you with any required documentation, and the type of documentation is dependent on the type of leave that they're taking. So if it's medical leave, it's a medical certification. If it's bonding leave for adoption, it might be adoption documents, etc. The worker has 15 days to provide you with the documentation. If they have difficulty obtaining any of the documents, you should provide them with a little bit of additional time. And then once you have all the documents, you have 5 business days to review everything and then let the worker know if they have been approved for job protection under FMLA. At that time, you should also let them know if they're required to use their PTO accruals, how they need to report in, if they'll need to provide a fitness for duty before returning to work, etc. Then the worker will report to the employer when they actually take leave, and the employer will keep track of that to ensure that they do not exceed the 12 weeks. And finally, the employer returns the worker to the job that they held before the leave. So it's the same job, the same terms and conditions, the same pay, etc. And the employer cannot insist that the employee is 100% fit for duty or totally recovered, because under the Americans with Disabilities Act and the Connecticut Fair Employment Practices Act, there may be reasonable accommodations that should be made for that employee when they return. Now, we know that there are some complicating factors for managing FMLA, and here are just a couple just to kind of keep in the back of your mind. So enforcing attendance and call-in policies is really important. Getting timely notice from workers and supervisors about absences. We know that managing intermittent leave can be tricky. For example, if someone is on intermittent FMLA because they suffer from migraines, that's not something they can predict. So they may be calling in, the morning that they're supposed to be coming into work because this is something that has happened. So it's important to track that. Calculating the average work week for a worker who works fluctuating work weeks can also be challenging. And, there are some things that are out of your control entirely, like incomplete or insufficient medical certifications. And we know that managing the interaction, if you do have more than 50 employees between Connecticut and federal FMLA, can be a bit tricky as well. It's important to note that even if a worker comes to you and says they don't want their leave to be designated as FMLA, if it is a reason that qualifies, it's your right and responsibility to designate that time off as FMLA, and it is a protection both for you and for the worker. Just a couple of other laws to be aware of that provide job protected leave. We've talked extensively, of course, about FMLA. There's also workers' compensation for covered on-the-job illnesses or injuries. The Americans with Disabilities Act, that would apply to you if you're an employer with 15 or more employees. The Pregnancy Disability Act, also for 15 or more employees, and the Connecticut Fair Employment Practices Act for 3 or more. And with those last 3 laws, that's where leave may be a reasonable accommodation. The only laws providing income replacement during leave are the Connecticut Paid Leave Act for employers with 1 or more employees working in Connecticut, and workers' compensation. And someone who is receiving workers' compensation or unemployment cannot receive Connecticut paid leave at the same time. So again, a lot of information. We do have a ton of resources on our website that I'd like to make you aware of. We have downloadable toolkits. We have an employer toolkit and also a human resources toolkit. And the human resources toolkit was really designed for anyone to be able to use, because we know that many small businesses in particular don't necessarily have an HR department so to speak. There's also materials that you can provide to your employees, like an employee fact sheet, a rack card, an employee rights poster. If you do have questions, we do not have a call center, but we do have a contact us portal on our website, which is ctpaidleave.org. So you can go in there, submit your question. And if you would prefer to speak with someone as opposed to communicating via email, you can just indicate that and someone will call you back, typically within 2 business days. We also have a couple hundred frequently asked questions on our website, and we have some helpful videos both on our website and on our YouTube page. We have some different video tutorials and things of that nature. And so with that, I will stop sharing. And I saw a couple things come in to the Q&A, so let me take a look at those. Janet asked, will the slides be available? Yes, the slides will be sent to you along with the recording. Another question was, can an employee take Connecticut paid leave and Connecticut FMLA at the same time, or do they choose which they would like to take? The answer is that they can be taken at the same time, because remember, FMLA is job protection, while Connecticut paid leave is income replacement. So whenever an employee comes to you and says they need to take time off from work, you have to sort of consider 2 questions. One is, does this employee qualify for job protection based on the reason they're going to be out? And the second is, how is this employee going to get paid while they're out? And that's where you would get into, do they have accrued PTO that they can use? Is there a short-term disability policy? Do they apply for Connecticut paid leave? And then I saw a couple of questions in the chat as well. Are there or will there be CTPL flyers to post in places of employment for workers? So yes, that's what I just showed you on that resources page that can be downloaded from our website, and that is already there. And then as far as any FMLA materials, those would come from the Department of Labor. And let me just read, there's a bit of a longer question, so let me just read it and make sure I understand before I try to answer. Okay, so the question is, how does federal FMLA and Connecticut FMLA interact with each other as of 1/1/22? Do we have to have a separate policy for each, or does Connecticut FMLA supersede federal? For example, no one can take leave for more than 12 weeks in any 12-month period. So for that question, I really would advise that you contact the Department of Labor, because as I said, Department of Labor oversees all FMLA related issues. So I know that Connecticut FMLA and federal FMLA can run concurrently in some situations, but they don't always have to. So just to have the most accurate information, I would advise that you look to the Connecticut Department of Labor for that. And I'm going to just see if I can quickly find that website to put in the chat for you all. And I was able to find it quickly. So I'm putting that in the chat. And then I will also put in the chat our website, Connecticut Paid Leave. The first one, the portal.ct.gov/DOLUI. That is the site where you'll be able to find all the new information for FMLA. No worries, Claire, about the flyers question. We are always seeking to provide more information that will help you communicate with your employees. So if you ever are looking for something and you can't find it, please do send that in through the Contact Us portal so that we can take that information and try to create something for you to be able to help communicate with your employees. So I don't see any more questions. I want to thank everybody so much for joining us early on this Friday morning. Again, the recording and the slide deck will be sent out to you within a couple of days. And please do check out our website and write into our contact center with any questions at all. Thank you, everyone. I hope everyone has a very happy and healthy holiday season and have a wonderful day.